After the Civil War, there are 3 new amendments to the Constitution. It is one of the most creative constitutional moments in the history of the country. And the 13th Amendment abolishes slavery and involuntary servitude. The 14th Amendment I'm going to come back to, and the 15th Amendment eventually prohibits race discrimination in voting. But the 14th Amendment is the one that becomes really the most interpreted amendment, the most litigated amendment in constitutional history. The first section of the 14th Amendment overrules Dred Scott v. Sanford and states that everyone born in the United States is a citizen of the United States, and that is intended to say African Americans now no longer slaves and they are citizens. But that part is not the part of the 14th Amendment that becomes the most important. In fact, there are 5 sections of the 14th Amendment, and the parts that people think are going to be the most important end up not being the most important. So in Section 1, there's a sentence that says that no state shall, and then there are 3 things that no state shall do. No state shall deny any person the equal protection of the laws, deprive any person of life, liberty, or property without due process of law, or deprive any citizen, not person now, citizen, of the privileges or immunities of citizenship. Those are the 3. The Equal Protection Clause and the Due Process Clause, those are the first 2. They have become the most litigated parts of the Constitution. The Due Process Clause in particular has been really tricky. So remember that case, Barron versus Baltimore, which had said that the Bill of Rights only limited the actions of the federal government, not the actions of the state government. So if the state government harms you, you don't have any individual rights under the Bill of Rights to sue. Over the course of the first few decades of the 20th century, that changes. And eventually, the Supreme Court incorporates, that's the word we use, the Bill of Rights against the states. Almost all of them, not all of them. It's still the case that the Third Amendment, which protects you from the quartering of soldiers in your home, has not been incorporated, largely, I think, because the issue hasn't really come up.
But the 14th Amendment also has other clauses that we've largely lost sight of. So Section 2 of the 14th Amendment was meant to ensure voting rights for African Americans. It basically said that any state that disenfranchises any portion of its population would lose representation in Congress proportionate to how many of its own citizens it disfranchised. Unfortunately, Section 2 of the 14th Amendment was never enforced. Congress went down the road of enforcing it several times, only to sort of stop and pull back. So no state, during the long period of Jim Crow, no state ever did actually face that punishment. But the drafters of the 14th Amendment certainly intended for them to. And then there's several other provisions of the 14th Amendment dealing with debts and things like that. But perhaps most importantly, Section 5 of the 14th Amendment gives Congress primary enforcement power. In fact, if you look at all 3 of the Reconstruction Amendments, the 13th, 14th, and 15th, they all end with a nearly identical provision saying Congress shall have the authority to enforce this by appropriate measures. And that's actually indicative of the prevailing attitudes towards Congress and the courts at the time. Right? So Congress is drafting these amendments. It's a Congress that's dominated by radical Republicans. They have just fought and won the Civil War. Meanwhile, they have a court that is still, to some extent, has members of this sort of old guard on it. There are still Democrats on the court at that point, and they're reacting against the Taney Court, right? As I said, the sentence 1 of the 14th Amendment is meant to overturn a Taney Court decision. The Republicans in Congress have no faith in the judiciary to carry Reconstruction forward. As it turns out, they shouldn't have had any faith in the judiciary to carry Reconstruction forward. The judiciary almost immediately, in the slaughterhouse cases, the civil rights cases, starts sort of peeling back the protections that Congress had attempted to extend, both in the Reconstruction Amendments themselves and in various pieces of Reconstruction legislation. But Congress was prescient in that regard. It regarded itself as the primary enforcer of the Reconstruction Amendments, not the courts.